So my name is Nagai Pendel. I'm the Dean of the Peter A. Allard School of Law at UBC, and welcome to the 19th annual J. Donald Mawhinney Lecture in Professional Ethics. So before we begin today's program, I would like to acknowledge that UBC's Robson and Point Grey campuses are situated on the ancestral and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh First Nations. I would also like to thank those of you on Zoom who may be joining us today from many places, near and far, and acknowledge the traditional owners and caretakers of those lands. So before we begin, just a few housekeeping items. So for the folks on Zoom, if you experience any technical issues, please reach out via Zoom chat for assistance. Please be sure to direct your question to the host. We have additional colleagues on the line whose webcams are turned off, but they are assisting on the back end. We'll have a short Q&A following the lecture. So if you have any questions for the speaker, please use the Q&A box to submit them. So the Mawhinney Lecture is one of the leading lectures in Canada on the topic of legal ethics, and it allows the law school to emphasize the critical importance of maintaining ethical standards in the legal profession. This endowed lecture was established in 2005 to recognize J. Donald Mawhinney's outstanding contributions to British Columbia's legal community, his commitment to legal education, and his dedication to practicing with the very highest standard of professional ethics. Mr. Mawhinney was an alumnus of the law school, graduating in 1954. He articled at Ladner Downs, now Borden Ladner Gervais, became a partner in 1959, and acted as managing partner from 1976 to 1978. In 1980, he and Howard Kello, QC, established Mawhinney & Kello. Over a period of 10 years, the firm grew to 28 lawyers whose primary focus was business law. In the 1990s, the firm merged with Fraser, Milner, Casgrain, now Denton's. Mr. Mawhinney served as vice chairman of the firm until 1994. Mr. Mawhinney was a firm believer in community service and served as vice chair and then chairman of University and Shaughnessy hospitals. This lecture would not be possible without the generous support of those who contributed to the endowment and the hard work of Mr. Mawhinney's son, Mark Mawhinney, who is the driving force behind this special tribute to his father. I understand that Mark is online watching the lecture. We'd hope to have a few words from him. We had a few technical difficulties, so my apologies for that. But thank you, Mark, for all of your work bringing this endowment to fruition. And so now I have the great pleasure to introduce our speaker today, Florence Ashley, who is an assistant professor at the University of Alberta Faculty of Law and the John Desater Health Ethics Center. They hold BCL, JD, and LLM degrees from McGill University and an SJD from the University of Toronto. Florence also served as the first openly trans feminine clerk at the Supreme Court of Canada. Florence is the author of Banning Transgender Conversion Practices, a Legal and Policy Analysis, and Gender/Fucking, The Pleasures and Politics of Living a Gendered Body. Please join me in welcoming Florence Ashley.
Thank you, thank you. All right, let me set up my phone so I can play Angry Birds while I talk. No, I'm kidding. Just making sure I'm a little bit on time and I don't go, too far over time. Now I want to thank the organizers for. Oh, okay, we have to move. All right, perfect. All right, so. First, I want to thank the Faculty of Law at UBC and the organizers for inviting me, and for everybody who's attending. I'm really honored that you're all here, although I'm a little bit concerned that you have nothing better to do on a Thursday evening. But that's fine, because now you're downtown. I think it's downtown. I don't know. I don't know Vancouver. But, afterwards you can go to Davie Street and be super gay for me, and that will make me happy. So perfect. All right, so my lecture, A Healthy Disrespect for the Law. Back in March 2018, there was a professor in the US who was confronted by law students who objected for his writing in support of the first Trump administration's immigration policies, and he invoked the rule of law to justify his position. And a student shouted, "Fuck the law." Hearing this, he responded, "Fuck the law, that's a very odd thing to say. You're all in law school. It's a bizarre thing to say, but fuck the law when you're in law school?" Coming back a little bit closer to our day, September 2023, I posted a lighthearted TikTok saying, "As a law professor who teaches criminal law, I feel compelled to inform you to be gay and do crimes." Would be my first, but not quite my last public controversy as a law professor. I'm really going for the high score here. Um, but the reaction from conservative pundits was surprisingly fast, with headlines asking whether it was such any way for a professor to talk. Ugh. As one writer pointed out, at issue is respect for the law, period. The law school's social media was flooded with comments that ranged from like incensed to hateful, and all had to be logged down. And I doubt that the criticisms were in good faith. In fact, I suspect they were probably much more bothered by the fact that I said be gay than the part that I said do crime. But both examples, my instance and in the US, really give way to some pressing questions for the legal profession. Why would it be bizarre for a law student to say fuck the law? Why would it be inappropriate for a law professor to tell people to be gay, do crime? I think here the underlying assumption is that law students and law professor owe some degree of greater respect for the law than those who are outside the legal profession. And this is not a rare view, as it's not the first time you hear it, I'm sure. In fact, the first comprehensive professional ethics code by the American Bar Association pithily stated, "To lawyers especially, respect for the law should be more than a platitude." And there's a related sentiment expressed in Canada's Model Code of Professional Conduct, whatever it's called. A lawyer must encourage public respect for and try to improve the administration of justice. Respect for the law, to quite a lot of people, really lies at the very heart of what it means to be a lawyer. Professor W. Bradley Wendell exemplifies viewpoint when he says, "Without the constitutive obligation of fidelity to law, lawyers are just sophists, offering nothing beyond the kind of half-baked moral advice that any decent client could supply for herself. If there's something distinctive about our profession, it has to be a commitment to the value of legality and a corresponding obligation to respect the law." Now, respect for the law is a pretty fluid notion. Doesn't have to mean that the law cannot be criticized, nor perhaps to some extent disobeyed. But there's still a sense of solemn reverence for the law as an institution baked into the idea. Jurists might say that the law is misguided, out of touch with reality, or perverse, but they shouldn't say stuff like fuck the law, fuck the courts, and fuck you. Well, I take the contrary view. I think that disrespect for the law is no more advice for jurists than for the lay public. Quite the opposite. If the legal profession is to be of any value to society, it has to entertain some measure of disrespect for the law. Reverence asks us to subdue our anger toward injustice. It asks us to see the law not as being just, a few shy steps away from justice. And so we have to quell our fury to the same degree. That can't do. No. As Robert Cover points out, legal interpretation takes place in a field of pain and death. In a business of violence, suspicion should be our starting position. Under the blazing light of the Canadian legal system history, function, and outcomes, that suspicion should, frankly, coalesce into disrespect. If the arc of the moral universe bends towards justice, as Dr. Martin Luther King Jr. has famously said, it's really only thanks to those who, before us, shared in a healthy disrespect for the law. If there's a professional virtue to be found, I hope to convince you that it's that one, a healthy disrespect for the law. Dramatic pause. So why are we talking about this? It's not an easy thing to join the legal profession. when I'm looking back on law school, and when you're looking back on law school, unless you're in law school, in which time you're probably experiencing it right now, we often focus on the sleepless nights, the brutality of first-year law, the stress of firm interviews. But what we tend to forget is the moral dimension of becoming a lawyer. Law school isn't just a matter of becoming a competent lawyer, but also wrestling with how to practice law within a system that's just not always a system of justice. What we tend to forget is the moral strife felt by law students who are orienting themselves towards justice at the same time as they're becoming a cog in what is ostensibly an injustice machine. Far from abating with time, this sentiment has been coming out of our law school more and more. We're really seeing a renewed vigor of those doubts. And this, frankly, shouldn't be a surprise. First, there's many marginalized students who come to law school from a place of ambivalence, if not a hostile regard for the law, given its historical and ongoing role in perpetrating and perpetrating injustices. I know I did. And as the number of marginalized students increase in our law schools, so will criticisms of the law. But that's not the only thing. This affected law students also just struggling with their relationship to the law because they see the world around them change in ways that are really challenging narratives that we have of the law and of law school and of the legal profession as really a source of progress and justice. The law has simply failed to counter rising income inequality, deteriorating standards of living, and widening racial disparities in the carceral system. The late stage capitalism has been girl bossing a little bit too hard. And rather than helping us, it seems like in many ways, the law just seems poised to serve the interests of anti-democratic populisms. Now, my aim is not to depress, so I'll only give a couple examples, but internationally, humanitarian law has repeatedly proved unable to prevent war crimes, crimes against humanity, and genocide, even when the countries involved take pride in being democratic and respecting the rule of law. In the United States, the decades of judicial infiltration by the Federalist Society has culminated in the Supreme Court overruling Roe v. Wade, paving the way for the criminalization of abortion in countless states. And it's this week and just see what the new Trump administration is doing. Didn't have time to integrate all of that into my speech, but it's kind of bonkers. People are already wondering if, how long birth control, same-sex marriage, interracial marriage, and even just desegregation will survive the onslaught. And in Canada, we've seen populist governments increasingly invoke the notwithstanding clause in order to target marginalized communities. In 2019, Quebec has used it to ban teachers, lawyers, judges, and law enforcement from wearing religious clothing, such as the hijab, burqa, turban, and kippah. In the last few years, some provinces have invoked the notwithstanding clause or threatened to invoke the notwithstanding clause to grant parents veto power over trans youth's choice of name and pronouns in schools, ban gender-affirming care for minors, ban trans women from women's sport, etc., etc. Some organizations have already started to deploy the same parental rights narratives to grant, in their own hope, parents veto power over abortion. This is not a US only issue. This is happening here. And so whatever rights we once had, they might soon be gone. And so it would seem right to be concerned in this context about an excessive tendency on the part of lawyers and citizens to obey the law. Why should we retain our commitment to the law if the law stands for injustice? What attitude should jurists hold towards the law as an institution? It seems that a good starting point would be to recognize that there are contexts in which we should respect the law. And there are also contexts in which we shouldn't. That seems pretty good starting point, right? Even in a world of angels, you need some sort of law for social coordination. The law depends on a significant degree of acceptance and obedience to fulfill its coordinative role. So we need to, take all that into consideration. As Robert Cover points out, this acceptance must come as a matter of course. taken for granted in this judicial act is the structure of cooperation that ensures, we hope, the effective domination of the present and prospective victim of state violence, the convicted defendant. The role of judge becomes dangerous indeed whenever the condition for domination of the prisoner and his allies are absent. Now, Cover doesn't starkly distinguish between different reasons for obedience, but it seems pretty clear that a legal system would pretty rapidly devolve into instability and grind to a halt if its legitimacy was questioned at every turn by those tasked with implementing it. Now, some people might think that's a pretty great idea. I'm not going to go so far as to argue that right now. We can have a discussion afterwards. But it seems pretty clear that the legal system does need some people, and especially officials, to accept its normative pull, its legitimacy, in order to function. And let us remind ourselves that lawyers are officers of the court. They're part of those officials in many ways. And they have to accept the law as something that should be obeyed and whose disobedience is blameworthy. In other words, the law depends on officials adopting an attitude of respect for the law. But it's also pretty darn clear that there are other situations in which we should not respect the law. Indeed, it's pretty easy to conceive of contexts in which we're bound to utter contempt for the law, where the legal system is so rife with injustice that its function cannot be described as anything more than structured inhumanity. It deserves nothing but disrespect. I hope we can all agree on at least two examples: Nazi Germany and the antebellum South. In a state that's defined by genocide and slavery, respect for the law is an evil. Indeed, the obligation to disrespect the law may bear even greater weight for jurists because of our unique role in upholding the system. And that comes with a corresponding ability to undermine it. And so, if we do owe reverence to the law or respect for the law, well, we owe respect for just laws being applied justly in a fundamentally just system. And on the other side of the spectrum, we owe utter contempt to the laws of a fundamentally violent and unjust system. Now, the more difficult question lies in, what do we do in contexts that don't quite fit either of those? Scholars of professional ethics and philosophers of civil disobedience have traditionally characterized legal systems like ours as being near just, in which case they give rise to an obligation to respect and promote respect for the law. What are we to do in such a system? Well, in a near just system, we find that jurists are in a double bind, right? If we look back to the modal code of conduct, we have to encourage public respect for the administration of justice, but also improve the administration of justice. It's a twofold obligation. And so these things, well, seem to be in conflict, right? Because on the one hand, encouraging public respect for the legal system seems pretty incompatible with a disrespectful attitude. And on the other hand, we have to try and make it more just, which can involve pretty sharp critiques that can hardly be characterized as particularly respectful. And so if lawyers are those who uphold the foundation of the legal system, it seems reasonable to resolve the tension, I would argue, by emphasizing the importance of respect for the legal system and constrain jurists to forms of law reform that maintain respect for the legal system, though they may be highly critical of specific laws. That's kind of the traditional liberal argument here, right? Jurists can disagree, even vehemently, but it can't cross the line into this impoliteness, irreverence, contempt. This is the position of Judith A. McMorrow points out. It's one thing to say that a general citizen can show both respect for an institution and defy some of its dictates. It's more troublesome to assert that lawyers can legitimately uphold and defy the law simultaneously. Personally, I struggle with this argument. Why? Well, put it simply, the argument simply cuts both ways. If jurists are uniquely responsible for the proper functioning of the legal system, then they're also uniquely responsible for its injustices. And if we're responsible for its injustices, then shouldn't we endeavor to disclaim them and do everything in our power to bring the legal system in alignment with justice, even if that entails some measure of disrespect? And since the law is a system of structured violence, police, bailiffs, and wardens dancing in the synchrony to the judge's pen, then should our starting point not be one of suspicion rather than respect? Now, to be sure, the shape and the measure of disrespect that I'm suggesting will surely vary based on the shape and the measure of the injustice. I'm arguing for a healthy disrespect for the law, not just anything goes. But we shouldn't so readily discard disrespect as an instrument of change. And while, the precise bounds of our duty toward the law are surely changed a little bit by virtue of your legal training, I don't think it means that we have an absolute duty to respect the law. I also don't think it necessarily means that we have a more stringent obligation of respect to the law. At times, our influence on the public's view may well generate an enhanced obligation to disrespect the law in the name of justice. When laypersons have to comply out of fear of punishment, we may be the last stronghold against injustice. All right, so we said near just system. How does our current system actually measure up? Because respect is earned, not owed. Bringing disrepute to the legal system is really just a problem, only an evil if it's undeserved. Now, I've suggested that jurists should begin from a place of suspicion and entertain a healthy disrespect for the law, commensurate with the measure of its injustice. Well, what is the measure of its injustice? Well, I believe that the measure of this injustice is such that our suspicion should coalesce into disrespect for the law as a whole, to a healthy degree, rather than just for individual unjust laws. As the esteemed Brennan Lee Mulligan points out, I don't know what you kids are up to, but I do know one thing. Laws are threats made by the dominant socioeconomic ethnic group in a given nation. It's just a promise of violence that's enacted, and the police are basically an occupying army. You know what I mean? Well, not entirely accurate, the critiques of command theory from H.L.A. Hart come to mind. The quote does provide us with a sort of framework to reflect on the purpose of the legal system in our society. Law doesn't just emerge by magic. It's created, shaped by the hand of legislatures, courts, lawyers, and law enforcement. As Richard Quinney explained, the state is created by that class of society that has the power to enforce its will on the rest of society. It's designed to serve the interests of the powerful. It does not do so in a perfect way nor in a simplistic way, especially in an electoral democracy, but it still does so. And in a capitalist society, this entails not only protecting the concentration of property in the hands of the few, but also facilitating as much of an accumulation of wealth as is possible without the sociopolitical system falling into an intractable instability. So pervasive is the law's role in maintaining the inequities of capitalism that some philosophers like Evgeny Peshukanis claim that a communist society would no longer have anything that can properly be called law. I'm not sure I agree, but it sure does hint at the degree to which law is structured by capitalism. We can also nuance and add to this analysis by recognizing the racial aspect of capitalism. The allocation of resources under capitalism is predicated on a racial hierarchy. And although racial inequality is certainly less stark today than it was at the time of Confederation, it remains that the wealthy are disproportionately white and that Black, Indigenous, and other racialized individuals are disproportionately part of the poor working class. And it's not getting better compared to certain decades ago. As Olufemi Taiwo explains, the world as a whole is formed from the areas of colonialism built off the transatlantic slave trade. Canada's economy actually greatly benefited from slavery, be it institutions like Scotiabank being funded by wealth derived from the slavery, or others like the Hudson's Bay Company selling commodities to an England that was greatly enriched by slavery. Moreover, Canada's existence is essentially predicated on the territorial dispossession of Indigenous peoples. Armed with the legitimating imprimatur of the law, European settlers stole the land we live on from Indigenous communities, whether through violence or deceit. And today, Canadian courts continue to operate under a fiction of settler sovereignty that legitimates the continued operation of settler law and dispossession. Racist laws and institutions really run through Canadian history. Canadian history is really indissociable from racism. Whether we talk about laws restricting Asian immigration and barring people of Asian descent from hiring white women to protect white businesses, laws prohibiting traditional Indigenous clothes, dance, and ceremonies, anti-Black and anti-Indigenous segregation laws and policies, the residential school system and its hair in the form of the child welfare system, institution and policies designed to enshrine white supremacy and racial capitalism as the law of the land. Anti-Blackness and settler colonialism have also shaped today's criminal legal system, which I'm invested in as somebody who teaches criminal law. The Royal Canadian Mounted Police's predecessor organization, the Northwest Mounted Police, was created essentially to control Indigenous communities as European settlers expanded westward, a road that the RCMP has played throughout its history. As for contemporary law enforcement, their philosophies and techniques were greatly influenced by the United States, whose policing history is entirely rooted in anti-Blackness. According to Elizabeth Hinton and Deanza Cook, the first wave of mass incarceration in the United States arose shortly after emancipation as Southern legislatures adopted laws to force formerly enslaved people back into an exploitative labor system that resembled the plantation regime in all but name. As Black communities migrated north to large cities, Northern governments began to cast Black people as uniquely dangerous and a law-breaking group in order to justify the expansion of policing and incarceration under the pretext of law and order. The war on crime in the 1960s and the war on drugs in the 1970s onwards trafficked heavily in racist stereotypes to justify the development of new proactive policing tactics and special units, acquired military-grade weaponry and crime reporting technologies, and advanced paramilitary deployments. Having moved north, thanks in part to similar racial stereotypes and law and order narratives, these techniques now very much define Canadian law enforcement. Working closely with prosecutors in a very marked us versus them thinking, it's these very law enforcement bodies who determine the real shape of criminal law. This is one of the first things that I teach my student when I teach criminal law, and captured by this quote by William Stuntz, who explained, criminal law does not drive criminal punishment. The definition of crimes and defenses play a different and much smaller role in the allocation of criminal punishment than we usually suppose. In general, the role it plays is to actually empower prosecutors, who are the criminal justice system's real lawmakers. The Canadian criminal legal system is just indelibly stained by anti-Indigenous and anti-Black sentiments. Over-policing and over-incarceration are at once colonial tools and an afterlife of slavery. Racial capitalism schemes of surveillance and control are evident in the outcomes of the criminal legal system. As the rate of incarceration continues to decrease across Canada, the proportion of Black and Indigenous people in carceral facilities continues to rise. Black individuals are being incarcerated at 2.5 times the proportion of the population, whereas Indigenous individuals are being incarcerated at a rate that's closer to 6.5 times their proportion of the population. It should really be no surprise that some have taken it to calling it the criminal injustice system rather than the criminal justice system. And time has simply not disappeared those injustices. There have been no reparations, no land back, no real recognition for Indigenous sovereignty, very little respect for Aboriginal title and rights. Law has simply not eradicated discrimination. It hasn't ensured access to safe drinking waters on reserve, and it hasn't ended wealth and income inequality. Because the law has never undergone that clean break from its past, rules that appear to be neutral continue to perpetuate and oftentimes aggravate inequalities. If we only owe respect for the law in a near just system, what are we supposed to be making of this? Sure doesn't look good. Canadian law is built upon a series of founding injustices. And reverence for the law is essentially asking us to ignore them. It asks us to pretend that the Canadian government is a legitimate sovereign and that the law is a neutral forum for society's ever progressing march to justice. But And justice is really not an occasional outcome in an otherwise fundamentally just system. Rather, justice is an occasional outcome in our fundamentally unjust system. The use of the notwithstanding clause to narrow who gets to participate in civil society and pursue a life-destroying law and order agenda is a lot less of an aberration than it is a return to form. Canadian law only looks near just for those who are privileged enough to be unhampered by the greatest of its injustices. For the greater numbers of Canadian society, its primary operation is to ruin lives. To quote Chief Justice Beverly McLaughlin, the Canadian legal systems is sometimes said to be open to two groups: the wealthy and corporation at one end of the spectrum, and those charged with serious crimes at the others. Everyone seeks the law, but to most people, the door to the law is simply forever closed. Given the pervasiveness and foundational nature of injustice to Canadian law, I believe that our suspicion should really become a healthy disrespect for the system as a whole, rather than just for individual laws. If injustice is unexceptional, so should our contempt for the law. We should foster a healthy disrespect toward the law commensurate with the measure of its injustice, and its measure is great indeed. All right, that's a lot of words, but how should we navigate disrespecting the law? When should jurists hold the law in contempt? Where's the line? Well, I don't believe that we should disrespect the law everywhere and all the time. We should follow the words of Mary Matsuda in describing multiple consciousness. There are times to stand outside the courtroom door and say, this procedure is a farce, the legal system is corrupt, justice will never prevail in this land as long as privilege rules in the courtroom. And there are times to stand inside the courtroom and say, this is a nation of laws, laws recognizing fundamental values of rights, equality, and personhood. Sometimes, as Angela Davis did, there's a need to make both speeches in one day. Is that crazy, inconsistent? Not to Professor Davis, a Black woman on trial for her life in racist America. It made perfect sense to her and to the 12 jurors, good and true, who heard her when she said, your government lies, but your law is above such lies. So even if you think judges aren't shit, you'll sometimes have to suck up. And a healthy disrespect doesn't have to mean undermining the law in those rare moments where it does actually serve justice. David Luban suggests that we only have an obligation to obey the law when the law corresponds to a moral requirement, or where obedience is a matter of doing our fair share within a fair and reasonable scheme of social corporation. Elsewhere, we don't owe it obedience, let alone respect. And so your starting position should be that the law deserves some disrespect, since it's rooted in injustice, filled with unjust laws, and applied with injustice. But to be healthy, your disrespect should be proportionate and should also be guided by a deep and authentic desire for justice. What makes disrespect healthy is its intelligibility, its ability to raise consciousness and to increase justice, or at least shine a light on its absence. Beyond that, I don't have grand advice. Justice is a matter of morality, and morality belongs to each and every one of us. The balance of a healthy disrespect is a question of conscience. It's not one that can be answered by others. Within each lauder's conscience, a touchstone, tells us the US Code of Ethics, without which we cannot lay claim to the honor of our profession. The most important thing that a lawyer can have is a strong moral compass of their own, not somebody else's, and a willingness to stand by it. Find your line and guard it with a fervor that can only come from love. To be a lawyer is to be involved in a system of injustice, to take part in a business of violence. I have personally no intent to stop telling people to be gay, do crime. It's one of my few pleasures I still have left in the era of Trump. And I also have nothing but admiration for those who, in the name of justice, dare to say, fuck the law, fuck the courts, and fuck you. Trash talk the law. Call courts fuckwits. Our legal order would only be better if we jurists collectively fostered that healthy disrespect for the law, because the arc of the moral universe may bend toward justice, but it's only thanks to those who share in that healthy disrespect for the law. Justice, not law, should be our measure. And as crises succeed one another at an ever increasing pace, we cannot allow ourselves to forget that. So be irreverent, be indignant, be defiant. The law is not sacred. People are. Thank you. Also, damn, I was real good on time.
So good on time that we have plenty of time for questions. So we have people online who can ask questions, but I'll turn first to the room. Questions, reactions, comments? I'll ask the first one then. And maybe I'll start at the end, which is, I mean, so many things struck me. But you talked about our moral compass, right? And our morality is our own. So how can we hear one another's stories, our narratives, our expressions of justice? I won't say without respect for the law, right? But without a system of social cohesion that allows voices to be heard, right? So it's and you touched on it a bit in your conversation, but I think for me, when I think about the value of law, and again, it's an internal compass, but I think about its ability to allow us to hear competing views, and then with that exchange of information, maybe we begin that march towards justice. But I wonder if you had any comments on that.
Yeah. I mean, whenever I think about that, the first thing that comes to mind is the fact that by and large, the law plays a lot less of a role in our lives than we often think. I mean, how many of us think about the law and whether something is legal when they're about to do something? Because first of all, uh, teaching criminal law, I'm pretty much convinced that like literally everybody does crime literally all the time by accident, and society just does not collapse because the definition of criminal law is just so absurdly broad sometimes that it entirely just devolves into pure discretion for the police. And so I would, I guess, begin with the question of like, is it really law that's doing that, or is it just the fact that to a big extent, and I know this is going to be controversial, but I think most people just aren't assholes. I think most people just want to cooperate with one another. I mean, the most beautiful thing is if I'm walking down the street and I smile at some random ass person that I'm passing by, 95% chance they're going to smile back. Right? That's just pure reflex. People just want to cooperate, to talk to one another. And oftentimes, when they don't, it's because we've built systems that allow for dehumanization, that allow for people not to see each other. Now, this isn't to say that there's no room for the law at all, right? I'm not saying that we should just, stop having any law whatsoever at any point in time. On the contrary, I think that, one of the central point is that the goal is to do law better, and to do law better, sometimes we have to trash talk it. Sometimes we have to call out the bullshit that's happening in the legal system and actually, tell it, do better. Just do better. And so, if I have to go to court, sometimes I will. I've never actually had to personally like kind of go to court to a trial, but uh, if I'm I don't know, if I get arrested for saying big to crime, and I have to defend myself, I will still like show up and actually try to defend myself. I will not just be like, come on, trail me. I don't know. There might be a time to do that, but I can imagine I would try to defend myself. But I really just don't think that there is that, that great of the risk of just anarchy suddenly taking on the moment we start having disrespect for the law. First, because I think law is just probably not that fragile. in the first place. But also, I mean, I don't know. I also have the question of like, well, is anarchy that bad? If you were going more classically, you know, it means the absence of hierarchy, of domination. That strikes me as a pretty good thing. And the goal of disrespect is to destabilize the system to a certain matter. Respect has to be earned, you know. And so to an extent, I think that oftentimes the problem is precisely that using the rule of law to prop up injustice is actually far more destabilizing. And that's how we end up with shit going like down, right? That's when you start having things like civil wars, like, you know, the whatever is going to happen in the US, which might soon enough be a civil war, TBD. But a lot of the worst stuff. And so, you know, I think we can find ways besides the law in many of social cooperation, because I think we just naturally cooperate in many ways. And also, I mean, people aren't cooperating and there's no law, you're just going to get punched in the face. So there's also that, that aspect of it. But also, you know, I think it's also just about making the law better, not about, you know, throwing the concept of law into the trash, but throwing whatever is going on that's passing itself off of the justice system into the trash. So that was a very long answer. Hopefully I half answered.
Thank you so much for this fascinating talk. When I think about healthy disrespect for the law by lawyers that was successful in pushing the law, I think about family law lawyers challenging no-fault divorce. Keep fabricating time and time again, people having grounds for divorce, whatever it is, you know, adultery, cruelty, tell them how to do it. And that actually led to a successful change in the law, to which is exactly what you described. But I think part of the price that came with this is that family law will forever have this particular image problem of these particular lawyers from these times that they have, you know, just a fabricated law all the time. So I wonder if you have any idea about what would it do to the image of lawyers. And I mean, I can only already imagine what you're going to say about the image of lawyers, but to the image of lawyers if they have constantly practiced this kind of healthy disrespect for the law. Would it have any kind of unintended consequences like the ones that I just described?
It almost certainly will have unintended consequences. As far as the repute of lawyers, I won't be the first to inform anybody here that, like, I mean, it's a race to the bottom at this point. So, you know, as far as saying that, like, family law has a repute problem, I think that might be true in terms of, you know, like, how do I put this politely? Intra-professional dick measuring contests, but but in broader society, most people think that like kind of all lawyers are kind of shit until they're defending them and representing them. So, you know, I think the reputational element is already a bit of a struggle, and to the extent that there is that sort of like reputational hurt, I think is just a cost that we have to assume in order to make the law better. And if there are some people who, you know, are like, if there is, you know, success in changing the law for the better, and then people, you know, act like that's a bad thing, I think, like, frankly, that's a them problem. You know, I think it should be something to take pride in, you know, to have found ways of actually changing the system and improving it. And so in a grand scheme of thing, I think it's just, on the one hand, it's not something that should actually have, you know, a negative reputational impact if you are actually making the law better, if you're making the law align with justice and with, well, social reality. So that's the first part of the answer. And the other part of the answer is, well, if that has to be the cost of justice, then that's a pretty low cost to pay.
We have a question online.
Yeah, thank you. Openly challenging the law as a marginalized person, especially in certain social structures, might risk significant prosecution. How do you think we should balance this reality with the importance of nurturing a healthy disrespect for the law?
I mean, that's a tough one. You know, I think that's part of that ends up kind of falling into my last portion of, you just kind of unfortunately have to figure it out for yourself, have to figure out what your risk tolerance is and how you can organize. There are ways to organize and to do work and to spread that disrespect for the law that minimizes the risk. Also, not all disrespect for the law is illegal, right? Because if you're just shit talking the law very publicly and you know, really bringing to light the negative aspects of the law, that's not necessarily something that's, you know, illegal in any way, shape, or form, or even more debatably in terms of like disciplinary codes. And one of the issues here is that that's really been like really underexplored in terms of like the disciplinary implications of how respect for the law works. And we've seen that notably with the way encouraging civil disobedience has been working in jurisprudence, and there's some interesting articles about that, including one that where the guy makes his point by just saying that he wants to beat up children, which is a very, very odd article. If anybody ever wants to read that wreck of an article, it's in the Alberta Law Journal, and you can in many decades ago, and you could just email me for a reference and I will send it to you. And so, I mean, I don't have a full answer. It's ultimately about balancing, and it's ultimately also about taking precautions. You know, the more precautions you take, the further you can go with your challenge of the system. But you know, I'm not saying that if you're especially at an especially great risk, maybe it's not the best idea to be like the first in the front line. But also sometimes people are too cowardly to be on the front line, and you're the only one left who's willing to do it. And then that's a cost that you have to ask yourself if you're willing to take it on.
Florence, thank you for this talk. I'm really stirred by this image of exuberant irreverence as a way of puncturing the law's pretensions and bringing it in greater alignment with justice. And I think you're right to suggest that that's got good prospects of being effective in realms where the law is most configured to interface with and care about democratic engagement. And yet I also think about the way over, you know, the past couple of centuries, and especially the past couple of decades, so many things have withdrawn from the realm of democratic contestation, right? That areas of policy like foreign policy and economic policy, everything that we have left the structuring and mediating forces of markets, of technology, all of these are areas in which we have structured injustice. And I guess I'm just curious if you see any prospects for bringing this kind of disrespect to bear on all of those frontiers where there's simply less democratic oxygen in the air in the first place.
So I want to preface this by saying that I'm absolutely not condoning any of the actions that I'm about to describe. I would just like to point out that certain things that are very much seen as completely outside of the realm of democratic government, especially in the realm of the market, have been shown to be not entirely so by some dude named Luigi in in the US recently. And so, you know, the reality is democratic governance is always going to be a matter of degree, because at the end of the day, everything that happens in human society is done by people. And so, yes, there is the, you know, the most most commonly what we think of when we say democratic governance is we really mean like within, an electoral system and things like that. But there's a lot broader than that. And even things that are just, already settled law is still depending on people just obeying it. And one of the things that comes to mind is Trump's attempt at, going after birthright citizenship, which has just today, I think, been blocked by by a judge. But I mean, that was entirely dependent on the judge's willingness to actually just like straight up apply the law. If the judge had been like, I don't care. And similarly, what happens if Trump is just like, yeah, I don't give a shit about what that court says. I'll still just do whatever the hell I want. Well, there's going to be a question of like, are people going to actually be, care enough about what the judge says to actually start, enforcing that, or care enough about the Constitution to actually enforce the 14th Amendment, if I recall. And so there's layers of popular participation at all levels, even if it's not the kind of prototypical democratic governance. And it does mean that it's a lot harder to bring things into the fold, but we shouldn't start from a position of thinking there's nothing to be done and that it's entirely outside the realm of what people can do. What's the saying? When there's a will, there's a way. And I'll leave it at that before I get in trouble.
We'll do the sequel to this talk, A Healthy Disrespect for Technology. It'll be great.
Oh my God, I have so many thoughts about that.
So first, thank you so much for that talk. I thought it was incredible. I'm a law student currently at Allard. And as you were speaking, I was thinking a lot about how the way that law is approached in law school, we're taught the law and how to apply the law. And unless you really seek out a lot of critical classes, you're not engaging very much with a disrespect for the law, or even sometimes feeling like maybe you shouldn't be disrespecting the law for job prospects and career and so on. So I guess my question is really, what role do law schools have to play in encouraging this healthy disrespect for the law? And can we do better? Should we do better?
Yeah, I mean, there's the what law schools should do and what law schools do. I won't be making a ton of friend by saying that I generally view law schools as like neoliberalism brainwashing school. And the reality is like a lot of the system of injustice, as much we like to think ourselves as above that, as members of the legal profession, structurally, that's one of the big functions of law schools, is to support that. And so can law schools do better? Absolutely. And I do think that, there's a lot of people, first of all, a lot of law professors who are absolutely amazing, and a lot of faculties are absolutely amazing that have been trying to bring a lot more of those critical discussions. And unfortunately, we see pushback in various forms against that, both internally and from outside. Being in Alberta, where, Danielle Smith has all of us on her shit list. It's a difficulty. I think it would be cool, and one of the things that I love in teaching first-year law, which is not a popular view because somehow people don't like teaching first-year law a lot. It depends on the people, but I will say they are a lot of work and tough to teach, and the students are always very depressed after midterms. But one of the amazing things, and why I love teaching first year law so much, is that I get to, come in and have them approach their entire law school with the ideas that I put before them. They don't get it in their last class, third year, and they've never thought about these things. And no, like we're coming in and like this, the first class, one of the first things I teach them, and the thing that I keep repeating to them the entire way through the 1-year courses, law is vibes. And there's no right or wrong answers about like 95% of the questions. And winning is all about making a judge want to side with you, usually through liking your client, and to giving them some sort of way of rationalizing that. And if you've got those two things together, you win. And the more sympathetic they are to your cause emotionally, the weaker your arguments can be, and vice versa. And I think, you know, that's one thing that I love teaching my students, and they absolutely hate it when I tell them that law is vibes until they like start doing legal clinic cases, and then they actually like show up in court and are like, oh my, and then they come back to me and they're like, oh my God, it is vibes. And I'm like, yeah, I know, I tell you, I wasn't lying to you. It's not my job to lie to you. That's, you know, that's going to be your job. I'm kidding. It's not the job of lawyers to lie to people. Well, sometimes it is, but we're not going to go into that. So yes, I think there is a big role for law schools to play in that. And, you know, it doesn't have to necessarily mean a radical restructuring of law schools. Sometimes it's just more subtle things of like, hey, you know, maybe let's just like from the get-go have more of an acknowledgement that, you know, sometimes the law ain't shit. And sometimes none of it makes sense. And sometimes judges will just like relitigate an issue that has been decided before like 8 times just because they literally couldn't be bothered to look up the precedents. And also somehow, you know, criminal law has, you know, hundreds and hundreds and hundreds of years of existence and still hasn't figured out some of the most basic doctrinal ask questions that we encounter. Telling the students that can be frustrating because they all want certainty. The first years all come in and be like, I want certainty. I want to know what the answer is. But, you know, at some point, once you repeat it enough, eventually they get into their head that like there is no such thing as certainty in the law. I mean, in my exams there is, but but you know, for the rest of it. And so yeah, I'm not going to repeat myself. So that's my answer.
Florence, thank you so much. Responding partly to what you just said, when I'm hearing all of this, just as a service provider, think of myself as a word plumber more than anything else in the practice of law. I'm thinking not just about advocacy in a broad way, but also how would a healthy disrespect for the law as an ethical viewpoint apply to a lawyer-client relationship? And I'm sure this is something a lot of law students encounter when they're going to their clinics, is working very closely with someone who's a subject of an unjust system and is having a direct experience of that injustice, and being taught by our traditional legal education to sort of be this, you know, this hype person for the law in a way that is very rational, like inconsistent with the experience that in many ways the lawyer's having. So I'm wondering what comments you might have on the ethical importance of a healthy disrespect and naming the injustice and the, you know, the bullshittery of the experience that clients are having.
Yeah, great question. So thank you. Also very nice seeing you. Like it's a tough one, right? Because like at the end of the day, I think the answer is it's gonna depend on your client, because at the end of the day, that's the person that matters here, right? When it comes to the actual lawyer-client relationship and what you're doing in a particular case, it's all about what, you know, they need, and how much, you know, disrespect you're bringing in or not is going to be dependent on that. And part of the problem is, well, that's going to change for every case and for every client. They all have very different, they're coming at you, first of all, for very different roles, right? You know, some of them are coming precisely for their sort of like comfort, and like also, let's be real, like a lot of clients sometimes seem to need therapists a lot more than they need lawyers, just to like work through, you know, work through shit. And I don't mean to like work through shit in terms of like, I don't know, like psychologically, but just like emotionally. Like people aren't coming to lawyers because everything's going great in their life. Well, there are exceptions to that, but you know, a lot of the time, and especially with people who are like not working in big corporate firms, people are having a difficult time, and what they need is different, right? And there are some people who argue me like, you know, happy to take their case just to call out the bullshit a little bit more. And there are a lot who aren't. And it's going to depend on the case, it's going to depend on the person, it's going to depend on so many things. And so I can't like really give a sort of like generic answer, but I guess the first point is, what does your client want? What does your client need? And what's helpful to them? And I think, you know, there's a people management element that I'm not generally the best at, and so I can't, you know, help a ton on that one. But it's something that hopefully, you know, there's a reason I'm not a lawyer. You know, I don't have the people skill to actually like do legal practice, and so hopefully you can get a better feel for it than I could. But I think, yeah, that's the answer. Is just, it's all about the client, it's all the person who's in front of you, and that's where that's what's going to dictate the boundaries.
Thank you for that. Thank you very much. You'll have me thinking, well, I say personally, I'll be thinking a lot tonight and over the week about you know, what we bring to the law and to legal institutions, what those institutions do to shape us and shape our relationships. And it's important to be critical about that interaction and what our individual agency is and that in those interactions. So really thank you for expanding my thoughts on that. We have a small token of appreciation for you. We have a reception following out in the lobby, so please join us there. And once again, another round of applause for Florence.
All right, see you all at the party.